Okay, let's unpack this. Imagine a legal framework, centuries old, running quietly beneath the everyday laws that govern our lives. Our sources suggest a powerful, historically rooted system that has been, well, simmering under American governance since the Civil War. It's a compelling, almost mind-bending idea that the United States might be operating under a continuous, undeclared state of martial law. Today, our deep dive explores a report titled Martial Law Precedent and Federal Authority, aiming to uncover the legal and historical threads supporting this extraordinary claim. We're talking about presidential power, failures of local government, and even symbols like the flag on a police uniform.
And what's striking about this report, I think, is that it doesn't present it as some kind of conspiracy theory. Not at all. Instead, it argues this is a logical, maybe even inevitable legal consequence of a framework created during a time of national crisis. A framework that, was never fully dismantled. It points to a dual legal system, meaning two parallel sets of legal rules operating at the same time. The everyday civil governance we all see, and then this underlying military authority. We'll explore its origins, its enduring legal power, and importantly, what this implies for how federal power could actually be asserted today.
So, where do we even start tracing the origins of such a profound claim like this? Our sources consistently point back to one pivotal document from the American Civil War, General Orders Number 100, better known, I believe, as the Lieber Code. What exactly was this code and why was it so significant?
Well, the Lieber Code really emerged from absolute necessity. You have to picture the situation. During the Civil War, President Lincoln faced this completely unprecedented legal dilemma. How do you wage war against a part of your own population, inside your own borders? He couldn't just treat Confederates as traitors pure and simple that had huge risks, retaliation, legal chaos, but acknowledging them as legitimate belligerents. That could imply recognizing their sovereignty, a real catch-22. So Dr. Francis Lieber drafted this very comprehensive code, 157 articles, to govern how Union armies should behave in the field. But here's the critical point for our discussion. It was more than just rules for the battlefield. It effectively established a legal operating system for managing a civil war against rebellious states. And its primary legal force was designed to be domestic, even though, yes, it did heavily influence international law, later things like the Hague and Geneva Conventions.
Okay, and one particularly consequential aspect was how it defined martial law itself. It wasn't something that needed some big formal declaration to actually begin, was it?
No, not at all. Very clear on that. Article 1 of the Lieber Code states it unequivocally. It says, "A place, district, or country occupied by an enemy stands, in consequence of the occupation, under the martial law of the invading or occupying army." And then the key part, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Plain. So this language, it establishes martial law as an automatic legal condition. It's triggered simply by military occupation of hostile territory. The army's presence is the proclamation, in effect.
Right, so it kicks in automatically just by the army being there. But what about ending it? What did the code say was required for this state of martial law to truly, definitively end? Because the report we're diving into suggests it never actually concluded after the Civil War, which, wow, that could change how we understand everything that came after.
That's absolutely a crucial point, and Article 2 lays this out pretty clearly. Martial law, under the code, does not cease during the hostile occupation, except by special proclamation ordered by the commander-in-chief, or by special mention in the Treaty of Peace, concluding the war, end quote. Now, the Civil War ended with surrenders, appomattox, and so on, not a formal treaty between sovereign nations. And critically, according to this analysis, no special proclamation was ever issued by a commander-in-chief that explicitly rescinded the underlying authority of General Orders Number 100 itself. So those orders, the ones governing the Army's conduct in hostile domestic territory, they were just left on the books, creating this dormant, sort of latent legal framework. And Article 3, just to add it, further clarifies the immense scope of this authority, suspension of criminal and civil law, military rule taking over if the commander decides it's necessary.
Okay, so we have this automatic, enduring framework established by the Lieber Code, but it also introduced a more nuanced concept, one our sources say is absolutely key to its modern relevance, this idea of a territory being fairly conquered. What does that term actually signify, and why is it so important to the argument?
Yes, this is where it gets really interesting in terms of ongoing application. Article 5 is central here. It states, martial law should be less stringent in places and countries fully occupied and fairly conquered. But then it says, much greater severity may be exercised in places or regions where actual hostilities exist or are expected and must be prepared for. Now, the report argues fairly conquered isn't just about winning battles. It's not simply military victory. It's presented as a dynamic legal test. Does that make sense?
A legal test, meaning?
Meaning, are the local civil authorities fully and successfully restored? Are they capable of maintaining public order, administering justice properly, and upholding the U.S. Constitution, importantly, without needing federal oversight or intervention? It implies a complete, stable pacification where the conditions that required military occupation in the first place are gone and, importantly, are not expected to come back. So Article 5 creates this kind of, well, a sliding scale of martial authority. You have less stringent rule, which might look like normal civil governance on the surface, versus the potential for much greater severity if things break down.
That's quite an interpretation of history. Did the report engage with, how this view might differ from standard historical takes, or maybe address any counter-arguments, like the idea that Reconstruction did end the military phase?
It does acknowledge that the common assumption is, yes, Reconstruction eventually led back to full civil authority. But it specifically counters that. It argues that Reconstruction, in many crucial ways, actually failed to achieve that fairly conquered status in parts of the U.S., according to the Lieber Code standard. If you connect this to the bigger picture, the Reconstruction era provides a powerful historical basis for this argument. Yes, military occupation of the South was meant to impose a new civil order, we know that. But its ultimate failure, politically and socially, left this legacy of unresolved hostility. I mean, think about the rise of groups like the Ku Klux Klan, the systemic disenfranchisement of black citizens that followed, the whole Jim Crow system. The report frames these not just as civil rights failures, but as, and this is their phrasing, acts of continued rebellion against the outcome of the war and the authority of the U.S. Constitution.
Wow. Continued rebellion.
Exactly. And the federal withdrawal of troops in 1877, which then led pretty directly to the Posse Comitatus Act in 1878. That withdrawal, the report argues, was a political decision driven by fatigue and compromise, not a legal declaration that the region was now fairly conquered in the specific sense meant by the Lieber Code. And the fact that the promises of the 14th Amendment went largely unenforced for almost a century afterwards. That suggests, according to this view, that the conditions potentially justifying greater severity under Article 5 were never truly resolved. They just went dormant, perhaps.
Okay, so let me see if I'm following this. We have this dormant, maybe legal framework from the Civil War, and this dynamic test of fairly conquered that arguably was never fully met after Reconstruction in some areas. How does this historical context then connect to things happening today? Our sources seem to suggest it links directly to systemic failures we sometimes see in modern law enforcement. Is that right?
Absolutely. That's the core of the modern argument. The report contends that the inability or perhaps unwillingness of some local police forces to consistently uphold constitutional rights for everyone. That isn't just a civil rights issue or a policing issue in isolation. It's framed as a contemporary manifestation of the breakdown of civil authority. And that breakdown, in turn, essentially represents a continued challenge to the constitutional order, which means, legally speaking, under this framework, those jurisdictions haven't met that fairly conquered standard. They're not fully pacified in the constitutional sense. And this is where things like the pattern or practice investigations by the Department of Justice become really critical, under the 1994 crime bill.
Right, those DOJ reports we hear about sometimes.
Exactly. When the DOJ issues a formal findings report detailing systemic misconduct patterns of excessive force, discriminatory policing, unlawfully suppressing free speech, the report we're analyzing argues that this is effectively a formal federal declaration that local civil authority in that place is fundamentally broken. It's failed its constitutional duty. And this condition, the argument goes, is functionally equivalent to those unresolved hostilities from the post-Reconstruction era. It leads to unrest, protests. It demonstrates a loss of consent by the governed, which is a sign of instability.
So these documented failures, whether they come from a DOJ report or are just evident in ongoing civil unrest, they could act as a kind of legal trigger, invoking that greater severity clause from the Lieber Code, dormant for so long.
Precisely. That's the argument. The documented failure of local policing provides official, concrete evidence that local authorities are unable or maybe unwilling to govern according to the supreme law of the land, the Constitution. This failure means the jurisdiction no longer meets the legal standard of being fairly conquered, as defined way back in Article 5. So under the logic of the Lieber Code, this removes the jurisdiction from the protection, if you like, of less stringent martial law and places it under the potential authority for much greater severity. The president then, as commander-in-chief, is empowered not obligated, but empowered to determine, based on military necessity presumably, whether to deploy U.S. military forces to restore constitutional order where local civil authority has demonstrably failed.
And this idea that local authorities are essentially acting under a kind of delegated federal responsibility, it's even reflected in symbols we see every single day. Our sources really zero in on the American flag, on police uniforms, on flagpoles, connecting it directly to this whole concept of overarching federal jurisdiction. That was surprising to me.
Yes, it's another interesting layer to the argument, how it interprets these symbols. Obviously, we don't have a single national police force in the U.S., but all law enforcement officers everywhere swear an oath to uphold the U.S. Constitution. That's universal. The American flag they wear or fly, the report argues, is therefore an emblem of that federal allegiance. It signifies their role within the federal system. He even points out that the U.S. Code, Title IV, Section 8J, actually groups police officers with military personnel when it talks about flag patches on uniforms. So the suggestion is this signifies they are, in a very real legal and symbolic sense, frontline agents of the federal constitutional system. This reframes local police not as totally independent entities, but as administrators of a delegated federal responsibility, a responsibility that's conditional on them actually performing constitutionally. And the flagpole hierarchy you see everywhere, U.S. flag always highest, visually represents this legal structure. Federal sovereignty is supreme. And when subordinate authorities fail that constitutional test, the ultimate authority can step in. It also, by the way, dismisses those gold-fringed flag theories you sometimes hear about as basically a distraction from this core constitutional structure.
Okay, so we've traced the origins of this latent martial authority. We've looked at its potential modern triggers through local government failures. Now, the practical question: how does a president actually activate this power in the modern era, if they decide to? Our sources point pretty directly to the Insurrection Act as the main vehicle.
You're absolutely right. That's the modern statutory key. We have the Posse Comitatus Act, which generally prohibits using the military for domestic law enforcement. That's the default. However, it has explicit exceptions. The Insurrection Act, that's Title 10, Sections 251 to 255 of the U.S. Code, is the most significant exception by far. Now, while one section, 251, generally requires a state legislature or governor to request federal troops, two other sections, 252 and 253, grant the president unilateral authority. No state consent needed.
Unilateral, okay.
Yes. Section 252 lets the president deploy troops without state consent to enforce federal laws or suppress a rebellion if it's become impracticable to do so by other means. And Section 253 gives unilateral power to suppress insurrection, domestic violence, unlawful combination, or conspiracy if it hinders the execution of laws or deprives people of their constitutional rights. And crucially, where state authorities are unable or fail or refuse to protect those rights. These provisions are seen as the modern legal tools to enforce the kind of ultimate federal authority first established conceptually by the Lieber Code.
So let's connect the dots. A documented pattern or practice of unconstitutional policing may be combined with significant civil unrest. That could potentially be categorized by a president as an unlawful combination or a situation depriving citizens of rights under Section 253. Allowing the president to bypass state objections, deploy federal troops, and essentially activate that greater severity of martial authority we talked about. And the report we looked at makes a particular point of highlighting President Trump's actions as a really critical modern case study here.
Indeed. The analysis suggests the Trump administration provided perhaps the most significant modern test and arguably reassertion of this kind of executive power. It moved it from something largely theoretical, maybe historical, right into the concrete present. His actions set a powerful precedent, regardless of how one views them politically. Remember, back in 2020, Trump deployed National Guard troops to Washington, D.C. He essentially federalized the city's police force, taking direct control, explicitly against the mayor's objection.
Right, I remember that controversy.
And perhaps even more significant, legally speaking, were his explicit threats to deploy federal troops to other major American cities. He named Los Angeles, Chicago, Portland, Baltimore, New Orleans, among others. And he stressed he would do it regardless of local and state opposition, whether the governors or mayors wanted it or not. His stated rationale was quite direct. I'm the President of the United States. If I think our country is in danger, and it is in danger in these cities, I can do it. That's almost a direct invocation of the spirit, if not the letter, of the powers potentially available under the Insurrection Act, underpinned, according to this report, by that latent Lieber Code framework. Now, there were legal challenges. I think one federal judge did rule that a planned deployment to L.A. violated Posse Comitatus under those specific circumstances. But the broader political and legal precedent had been set. A modern president asserted the right to use the military to solve domestic policy problems based on his unilateral assessment that local government had failed. So when you pull it all together, this deep dive really reveals, well, a truly thought-provoking conclusion, doesn't it? The United States, according to the specific analysis we've been discussing, operates under a kind of dual legal system. There's the visible, everyday civil governance we're all familiar with, and then there's this deeper, historically rooted system of military authority, ultimately vested in the president as commander-in-chief. An authority which, the argument goes, has remained legally viable since the Civil War and has now been demonstrably reawakened or reasserted in recent times. The Lieber Code, with its critical fairly conquered standard, combined with the modern Insurrection Act, provides, in this view, a clear legal pathway for this pretty profound executive power.
It really does make you rethink the perceived limits of executive power, doesn't it? The idea that systemic failures at the local level could legally justify federal military intervention domestically, and that recent events haven't just tested this, but have actually solidified the precedent. That's a powerful concept to grapple with. So what does this all mean for you listening to this?
Well, I suppose it means understanding that beneath the surface of our ordinary civil laws, there lies this deep, potent, historically grounded authority that presidents can potentially invoke. The question now, perhaps, isn't really if this power exists legally, according to this viewpoint, but maybe when and how it might be used again in the future. And critically, what safeguards, if any, are truly effective in practice to prevent its misuse. Definitely something to think about long after this deep dive ends.